Great.
Yes, Sunita, we can hear you.
Excellent.
Okay.
So I will continue. So I'm Sunita Kaminya. I am UN Women's Policy Specialist for Ending Violence Against Women and Girls in East and Southern Africa. We can go back to the first slide, please. Sorry, I think the first slide. Great. So just as a background again, today's presentation will go through a bit of the background and objectives of why we conducted the study. Sorry, if we can go back to the first slide, please. Thank you. And then we'll go through some of the key findings from the research that was conducted in 10 countries, and then promising practices that were identified in the context of the study, and finally, recommendations for how we can take forward some of this learning. So with that, I will we'll go back into the background now. So again, the study was conducted in 10 countries in East and Southern Africa, in Burundi, Ethiopia, Kenya, Malawi, Mozambique, Somalia, South Sudan, Tanzania, Uganda, and Zimbabwe, on how women and girls could access justice. There were 4 main objectives for the study, which were to document the discrimination faced by women and girl survivors of violence in the process of accessing justice, looking both at statutory and customary laws and legislative frameworks, also looking at what happens in practice, identifying and mapping promising practices in ending violence against women legislation and policy frameworks, compiling the data that was available and practices around survivor support through this journey, and identifying some priority areas for programming and policy support that different actors could bring together within the UN system, across civil society, government, and beyond, and wider development partners. The methodology involved quantitative and qualitative methods, including snowball sampling for the identification of participants and stakeholders, as well as triangulation with desk review of literature and publications that were available. Together with the online questions and surveys were conducted with 663 respondents. 58% of those were female, 42% were male, as well as 30 focus group discussions, which across each of the 10 countries involving traditional leaders, women, community-based organizations, virtual meetings, and case studies. I should note that the study was initiated prior to COVID-19, and the methodology had to be adapted because of the pandemic and the restrictions that were in place. So that was one limitation of the study, but we do hope that its findings can still be valuable as we grapple with the COVID recovery process and moving forward. We go to the next slide, please.
Sunita?
Yes.
Sunita, can you please slow down? Sorry, can you please slow down for the interpreters?
Sure, no problem. Thank you.
Thank you.
So if we go to the conceptual framing of the study, based on understanding that the right to access justice is a critical piece of realizing the rights enshrined under the Convention on the Elimination of Discrimination, all forms of discrimination against women. And it recognizes that access to justice has different aspects, which include the justiciability, the availability of services, accessibility of services that need to be of quality, and also making sure that there are remedies for victims, and this justice system itself is accountable to survivors of violence and women and girls who are seeking its services. Related to this conceptual framing, we go to the next slide. I hope my pace is better with the interpretation. Okay. Okay, great, thank you. When we look at, again, access to justice, there are a few key elements that we need to be assessing. And these include the enabling environment, and that links with how the legislative and policy frameworks are harmonized both within national frameworks, but also looking at international standards. A second aspect is ensuring that justice institutions are not only effective in their delivery of services, that they are accountable to clients and those seeking justice services, and that they are gender responsive in how they operate, so that all women and girls can access equally their right to justice. And finally, we need to make sure that that women and girls are legally empowered to access and enjoy their rights. And importantly, this means that there need to be men and boys who stand as allies in upholding women's rights and in supporting access to justice, that it's not just about women and girls. We go to the next slide. As we begin to look at the navigation of the justice continuum and women and girls' experiences in it, it's important to understand the context of violence, because one of the key elements of this study was looking at the experience of survivors of violence. So prior to, and again, this data was collected prior to COVID-19. So when we look at the information available on intimate partner violence, what we see is that there is data being collected, and the figures for sub-Saharan Africa are higher than that of the global figures. So 20% based on WHO data collected in 2018, as of 2018, compared for sub-Saharan Africa, compared to 13% for the global figures based on data available in different countries. And we can see on the map that there are still some countries where we don't have prevalence data on violence against women. And this is intimate partner violence, which is the most common form of violence against women. We also know that if we were to look within countries and with specific subgroups of women and girls, such as young women, women and girls with disabilities, women in rural areas or from lower socioeconomic groups, that we would see higher variances with the data. But we know that often this data, the available data, is not disaggregated to those levels. When we look at lifetime non-partner sexual violence, this figure actually is actually 6% is the more updated figure from 2018. But again, it's important to remember that most women and girls do not report their experiences of violence due to different barriers that they face within society, within service providers. So we always must remember that actual experiences of violence are higher than what the data will show. Now, if we go to the next slide, we jump into the findings of the study, beginning with the enabling legal, legislative, and policy environment. What we can see is that from the 10 countries in the study, there are laws and policies, whether it's enshrined in the Constitution or in other specific legal provisions, that uphold gender equality, non-discrimination, and protection from violence. We also see that across countries, there has been ratification of key international human rights conventions, such as the Convention on the Rights of the Child, the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW, and the Convention on the Rights of Persons with Disabilities, or CRPD. We also, for the most part, see that there has been all 10 countries, have signed the Maputo Protocol on the rights of women in Africa, and 7 of those 10 countries have ratified it. Additionally, there's overwhelming commitment to the Sustainable Development Goals, the Beijing Platform for Action, and UN Security Council Resolution 1325, in addition to other resolutions on women, peace, and security that are obligations of UN member states, so including the 10 countries in the study. So this forms a very strong foundation for upholding the rights of women and girls in accessing their rights to justice. But we also know that because customary law operates alongside the statutory law, and in some case religious law, that this creates a legal pluralism that is quite complex for women and girls to navigate as a justice structure. It is also important to note that when we look at the implementation and the effectiveness of this legislation, it's not always consistent. So just because the legislation is in place or has been adopted doesn't mean it's been practiced. Similarly, we do know from the study and what we saw from the the respondent surveys, that the laws, having the laws in place did make a difference on people's awareness of violence against women and girls, and the fact that there is a right to access justice services. At the same time, we know that monitoring and enforcement of the commitments on really how they're practiced and put in place remains a challenge. So it's important that we can recognize that the legal and policy frameworks are an important start, but are not drivers alone to really realize the vision for access to justice. Now, if we look at judicial mechanisms on the next slide, what we can see again is that across the countries, with almost all exceptions, there is a recognition of both statutory and customary justice delivery mechanisms. So whether that's through the courts or whether that's through traditional justice systems, community-based customary systems. And the legal framework recognizes those customary courts with the exception of Burundi and Kenya, even though those customary justice practices are used in the context of how the rules operate. We also could see that there is equal weighting for women and men's testimony in courts. But again, we see that there's discrepancies and gaps between how the statutory and customary provisions treat access to justice for women, treat the issue itself. And we can see, and there's a few examples that are presented in the presentation around the different types of justice delivery systems. And this from formal courts to religious justice systems to justice support institutions, in some cases, specialized courts. And here we can see that really there is a diversity of options, but also that that diversity can create some complexities in how justice is delivered and accessed. And once again, we see that there are variances across country in the context of the principles that are enshrined in the law and in the justice system related to women-friendly justice practices in regards to, for example, mandatory training for police and judicial personnel, in how access to justice is actually referenced and the types of practices we see, and legislation with regards to specific justice measures such as gender desks at courts or gender courts. Now, if we go to the next slide, this will now be highlighting some of the perceptions from the various from the stakeholders on survey that was conducted across the 10 countries. And what we saw, which reflects, again, the knowledge of the law, is that 86% of those 600 plus respondents were aware of places to access justice for women, and only 14% were not aware of that. And 82% of knew of official internet sites where legal information could exist. So that's an important reflection of the knowledge that is out there on what is at least on paper or should be available in practice. Now, if we go to the next slide, what we can see is that there was perceptions of participants and respondents around the importance of community justice practices in how women and girls can access justice. So the community practices are really influential and play an important role in the justice continuum. But we also could see that respondents noted in particular countries that justice institutions did not always take seriously threats or pressure. And in this way, it is possible that this creates a barrier to women and girls for pursuing their right to access justice. More than half of participants or respondents recognized that women from low socioeconomic backgrounds could access legal aid, but quite a few could also, and I think that it's meant to rate 41%, quite a few were not able to, did not believe that poor women and girls could access the legal assistance. I want to just pause and make sure that the interpretation of the international sign is still on, because I'm not seeing that on my screen. So I just want to confirm that before I continue, if that's okay. Very good. Thank you. Great. Thank you. So in terms of who is resolving disputes, what we could see, and which is not surprising for those of us who are working in the sector or familiar, is that family members, neighbors, friends are the first source of support over the formal institutions or justice systems. Traditional leaders also came high, as more than a fourth of participants would go to them for resolving disputes. So again, the importance of community mechanisms, the importance of that peer social support is really critical actually in strengthening women's access and girls' access to the justice chain. And that's something we'll have to remember as we move forward. We go to the next slide. Great. So in terms of perceptions of respondents around how the sentencing or how justice is carried out, there are some concerning findings here. So in cases where there is compensation required from the judgment of a court, for example, more than half, almost 70%, 69% believed that that clients or survivors did not receive compensation for their cases, even when it was mandated by the court. There was also concerning findings around how corruption is normalized. And almost half believed that corruption had been normalized in the context of accessing justice and in the courts. And quite concerning is the fact that almost 60% of respondents agreed that judges request bribes from clients when seeking. So we can see really clearly that some of the barriers coming through. We go to the next slide, and this is linked again to trust in institutions. What we saw is that 41% of the respondents believed that women had trust in traditional leaders for resolving their disputes and accessing justice. 46% had trust in courts. So again, less than half in traditional leaders and courts, but 72%, the majority, had trust in religious institutions for justice, which is another really important reflection of how different resources within the community and institutions can be partners in improving the justice chain for women and access to justice. If we go to the next slide, we want to also reflect on the impact of COVID-19 on access to justice for survivors and victims of violence. So as we've seen since last year with the COVID-19 pandemic, there has been a significant increase of intimate partner violence and other forms of violence because of the pandemic, recognizing that homes are not always safe for all women and girls. There's also risk of other forms of violence linked to the closure of school and loss of education, loss of income, and peer supports, which can also be a protective factor. This can contribute to this has contributed to potential rise in child marriage, sexual exploitation and abuse, adolescent pregnancy, and related negative consequences. We also know that the delay in education is stalling progress, but also reducing the protective factor for women and girls that it brings, and that there is increased burdens of unpaid care work that also has long-term consequences for women and girls. And those who are moving when are required to move in lockdowns, such as those carrying out essential services or those in informal work, often face harassment, whether it's through crossing borders or just seeking services. And sometimes they lack the PPE, the protective equipment to support them to prevent the transmission of COVID. We also know that COVID-19 has brought a shift in the referral services and pathways available to survivors of violence. This, again, has been impacted by movement restrictions. It has been affected, it's also been affected in the shift in health services to focus on COVID-19, often reducing access to sexual reproductive health and rights and services. It's sometimes affected the operation of helplines and legal assistance if they were not able to operate virtually or shift their functions. And of course, there were sometimes perceptions that those services, even when they were operational, were not functioning. So, for example, community members might believe that police would not be taking calls on issues of gender-based violence in the same way as they were before. Shelters perhaps could not always receive and accommodate as many individual clients, given the need for social distancing or other measures. And in terms of the justice delivery, we see that courts have been closed. There were limitations on the types of hearings conducted. And this added to the pre-COVID backlog of cases affecting women and girls, which was already a concern prior to COVID-19. Finally, it's important to recognize, related to this, that women and girls were also more economically vulnerable because of their engagement in informal work, because of disparities in women's economic empowerment. And the closure of justice services also affected their ability to get recourse related to that their economic rights, which is something that is not always made visible. The use of technology is also another point that is worth highlighting, in that while there was a lot of shift to virtual technology and platforms and ways of engaging, including in service provision, there was already disparities in women and girls who did not have access to mobile equipment or internet, including women and girls with cognitive, visual, and audio impairments. So it's really important that we recognize, on top of the complexity of the justice system pre-COVID, the COVID-19 pandemic added a layer of challenges that we really have to look at very carefully as we move forward and into the future. We go to the next slide. Some positive measures that were taken and some examples of good practices. If we go to the next slide, it's still coming. There were some great examples identified in the study. And again, these are just examples of ways that different countries and states and organizations have responded to COVID-19 and made available services. Sorry, could we change the slide? Thank you. So for example, in Ethiopia, and I hope the slide will come up soon, apologies for that delay, there was advocacy done which resulted in the decision by the Supreme Court to ensure that domestic violence cases were heard as a priority, even when there were changes to the court system in the closure and reduction in hearings across the courts in general. In Kenya, what we saw was that there was e-learning or virtual learning for police training, which had institutions which focused around issues of gender, inclusion, and responses to GBV, recognizing the increase in cases and violence triggered by the pandemic. So really ensuring that accessibility was made available. In Malawi, there were hotlines set up so that women and girls survivors could access coordinated support across the different referral pathways and mechanisms. In Mozambique, it was noted that courts issued interim protection orders against harassment, in addition to the protection orders against domestic violence. In South Sudan, there was cooperation with bar associations and other bodies of lawyers and advocates, recognizing the importance of bringing together service providers and coordinating approaches to response. And in Uganda, the Legal Aid Service Providers Network collaborated with civil society organizations under the EU-UN Spotlight Initiative, so that there was support available, again, a mobile line for survivors of violence to access legal information over the telephone. I'm going to pause briefly to just confirm if there is a challenge with the screen, because on mine, I'm still seeing a previous slide.
Sunita, we can see the slide you have just presented. So maybe it's your...
Oh, excellent. Okay. Perhaps it's mine. Excellent. Glad that it's working. So now if we go to the next slide on key barriers, and I hope that's showing up. I don't know what's happening with my
screen. Yes, it's showing up already.
Excellent. What we see again is that there are various hurdles that women and girls have to cross in order to access justice, beginning with the overlapping forms of exclusion that individuals face based on their own sex and gender identity, based on their poverty status, their abilities, based on their ethnicity or geographic location, their sexual orientation, migratory status, language. So these are some of the areas and factors that affect exclusion. We also know that there are attitudinal and societal barriers related to stigma faced by survivors, police victimization that blame survivors for their experiences, gender stereotypes that can act as barriers from reporting abuse. There's limited knowledge of the law and rights, both by individuals who have the right to access justice and also those who have the obligation to provide services. And then there are the issues of low trust in formal justice systems and the police, as we saw earlier. The system itself also has challenges in regards to the capacity to actually process cases, as we heard around the backlog of cases, and understand the needs of specific groups of women and girls. There's financial challenges related to the under-resourcing of the justice system. There's inadequate implementation of the mechanisms and the laws in place. There's sometimes case manipulation and delays, and linked, as we said earlier, also saw earlier, to the corruption. And there's the cost itself that for pursuing justice that is often borne by the survivors going through the process. Structurally, there's also discrimination on paper and in practice. We know that there's often exclusion of women from traditional arbitration committees. There is sometimes low representation of women in formal justice processes and systems. As we heard before, there's an inconsistent approach to how the law applies within the plural legal system. And there are discriminatory laws and decisions that still exist, as well as legal identity barriers, where again, linked to the different forms of exclusion, some women and girls don't even have the basic assets to initiate the process due to those legal identity. So really altogether, this makes a question mark on whether or not women and girls can access justice. Now, if we go to the next slide, we look at discrimination against specific groups of women and girls. And what we can see is that we know that women and girls living in poverty, women and girls living in rural areas, far from services, women and girls with disabilities, including physical, hearing, visual, cognitive, or intellectual impairments, lesbian, gay, bisexual, transgender, and intersex persons, migrant, displaced, and refugee women and girls. These are some of the subgroups of women and girls that face various barriers. Again, whether it's due to the lack of knowledge by them of their own rights, because of the way that information on rights is made accessible and made available to different groups, or the lack of knowledge by service providers on the rights of those specific women and girls and their specific experiences and needs within the justice system. There are also environmental barriers where the system itself is not set up in a way that women and girls, those specific groups can access it. There is sometimes discrimination or criminalization even and stigma from service providers, as well as family members and community members who would otherwise be the supporters and encourage women and girls who are seeking access to justice. So these are some additional barriers that we need to keep in mind as we're thinking about solutions. If we go to the next slide, some promising practices that have been identified in looking at approaches, and there are 6 approaches here that are recognized as important in providing support to survivors of violence through the justice system. And that includes ensuring that there is a survivor-centered approach, recognizing the rights and the decisions of the individual survivor and not having that decision be taken away from her. Ensuring that there is legislation on the provision of funding, again, reducing the burden and the costs of seeking justice from survivors, strengthening the justice system itself both formal systems and customary system, whether that's training, integrating curriculum, whether that's skill building for the specific magistrates of these systems, or having paralegal services and assistance for accompanying women and girls through the system. Having interagency coordination, such as recognizing that different institutions and mechanisms are going to be involved in the pathway through justice. Having initiatives focusing on the needs of specific groups of women and girls, recognizing the different forms and barriers experienced, and also looking at how the different laws and policies can be monitored and evaluated, because unless we have tracking of where there is progress and where there are gaps, we will not be able to close that implementation gap. So now moving into the final set of slides on recommendations. We have recommendations. We have about 18 recommendations that came from the report that are broken into 4 different sets. So starting with looking at how to improve the legislation and enforcement of legislation, there was a recommendation that there's a need to remove retrogressive laws, enforce those laws that exist and uphold the rights of women and girls, and continue to ensure that all forms of violence against women and girls are criminalized. There is also a need to ensure that the legislative provisions around protection of women and girls is actually enforced in practice. And this, again, links with the need for managing data, monitoring the process of implementation, and through investments. There's also a need to ensure that there's compensation for victims, which includes their access to inheritance rights and child support, not only their physical protection, but also their economic rights. And recognizing the need to promote women's property rights and economic status, which again can become a protective factor against violence. If we go to the second set of recommendations, this links to strengthening the justice system. So building on some of the good practices we saw, it's important to hold perpetrators accountable and address impunity. And this includes ensuring that there is effective and respectful communication with survivors and those seeking justice so that they feel supported by the system itself and not that they are the ones who perpetrated a crime. It's also important to invest in a sector within the judiciary that is focused on issues affecting women and girls, investing in expanding the number of female judges, recognizing the disparity that currently exists in their participation at different levels, and considering whether it is feasible and appropriate to establish and invest in women-only courts or specialized courts on GBV to address the specific backlog and context of cases in the country. It's also important to recognize and have different justice avenues, not only in cases of violence, but how that women's economic exploitation makes them more at risk of violence, and having specific support for them to be protected against that economic exploitation. And also, as I mentioned earlier, feminizing the justice sector, recognizing that similar to having more female officers in a security institution, having more female personnel in the justice institutions influences and affects women's experiences of the justice chain and continuum. And it's also important, of course, to institutionalize and sustain the training for justice personnel, including police officers and prison staff related on access to justice for women, because we understand there is changing the attitudes and practices of individual institutions requires changing the attitudes and practices of individuals within those institutions. Finally, the next set of recommendations looks at survivor-centered approaches, recognizing the diversity of women and girls. So first, there is a need to really identify and eliminate the obstacles and barriers faced by women in the process of pursuing justice, as identified earlier in the slide earlier. Second, there's a need to really ensure that there are stronger mechanisms for protecting survivors and victims, and also recognize the cultural consequences and community backlash that they face. So what's not necessarily written on paper, but what occurs in practice. Third, it's important to make sure that the information is available on the different options for women and girls to seek justice, recognizing the complexity and the diversity of options within the plural legal system, and recognizing some of the barriers that they may face in pursuing support through specific institutions. And finally, it's really important to create policies and laws that promote disability inclusive services for women and girls to access justice. One of the challenging findings of the study was the low level of accessibility for the justice services that were made available.
Sorry, Sunita?
Yes.
The slides are not moving, and I'm just wondering whether Joshua can just put the slides well so that it can align to your discussions. Several comments have come up on the same.
Great.
Thank you.
Actually, we are on the same page. The last slide is what Sunita is speaking to now, creating policies and laws that promote disability inclusive services. So we are now aligned.
Great. And now, Joshua, great. Can we go to the next slide, please? The community level actions.
We are there.
Okay, somehow on mine it's not changing, but great to know that it's there, I hope. And we will be sharing for all participants the presentation as well as the full study. And we'll share soon the link to the page where you can access the executive summary as well of the study, and the full study will be made available in the coming days. So finally, the last set of recommendations relate to community level actions on how the efforts can transform the social norms that really, again, are also barriers to women's access to justice, women and girls. So first, it's really important to ensure that traditional authorities understand gender issues and that those committees, the customary committees, have women represented and also support gender sensitive approaches and processes that can be led by women or include women at a minimum in decision making. Secondary, it's important that customary laws align with constitutional provisions on fundamental rights, human rights of women and girls, as well as the international human rights standards, recognizing that all the countries in the study and many countries beyond have agreed to those standards and need to just put them into application. It's also critical that customary laws, which are discriminatory against women and girls, are declared illegal, such as child marriage. And it's very important to take a comprehensive strategy in engagement with traditional and religious leaders, as well as cultural authorities, which will not only look at their promotion of issues of women, of access to justice, but that they transform and support more gender-sensitive community dispute resolution processes. They understand and respond to the distinct needs of women and girls in just seeking justice, and that they model from themselves and promote positive masculinity, as well as ending harmful practices and gender stereotypes that are perpetuated and replicated within communities. And finally, it's very important to continue to develop and strengthen existing coordinated community responses on matters of ending violence against women and girls, recognizing the different roles of institutions and individuals in addressing the issue. So with that, I thank you. I also appreciate the understanding in some of the technological hiccups in the session, and we'll pass the floor back to Jack. I know we will be going through a panel discussion to look at these issues more in depth briefly, but I'll pass the floor back to you, Jack, first. Thank you.
Well, thank you so much, Sunita. We appreciate having taken us through the key findings and recommendations of this study. For colleagues who joined when Sunita was already presenting, Sunita is the regional policy specialist in charge of ending violence against women and girls at UN Women East and Southern Africa. And she has just finalized the presentation on the findings and recommendations of this study. We will move forward to a short video which is related to the study and looking at the role of men also in ending violence against women and girls. And I invite Evelyn Ongige, who is also with us at UN Women SRO, to present that video before we can proceed to the panel discussion. So Evelyn, please proceed and put the show the video. We cannot hear the sound, colleagues. There's no sound, Josh. Very good, we can hear. Thanks.
Ine ndi Musa Meshaki Nkumbatsala utumiki umene tikuchita panopa wa barbershop kapena kuti male engagement spotlight uli bwino kwa ife chifukwa kuti mbuyo mumene timakhala mwina nthawi zambiri timalekerera nkhanza zokumachitika pakati pathu ndipo sitikadziwa kuti tingachite bwanji. Pano titabwera bungwe limene la CLICOM ndi programu imene ya spotlight ndipo itayitanisa mashehe komanso azibusa onse makadera la Kawenga. Tinakhala pansi tinaphunzitsidwa bwino lomwe mmene tingachitire kuti tikhonzanso kuwako pa banja bambo kuti tikhonza kumakambirana zina zimene zikhonzanso kuchepesa nkhanza pakati pathu. Tifeyo ngati mpingo tidawayamba ndithu programu imeneyi makaso yokhazikitsa azibambo pamodzi achinyamata pamodzi kuti akhonzanso kumakambirana zokhuzana nkhanza. Chifukwa china kuti pamene tikukambirana anthu ambiri amasuka kumakambirana zimene zikuvuta pakati pathu komanso za nkhanza zina zimene zili pakati pathu zimene zikuonetseratu kuti pakati pathu ndi nkhanza zimakhalapo. Anthu ambiri akuzindikira komanso nkhanza zikuchepanso pakati pathu ndipo zaonetseratu pamene nkhanza zimene zikuchepa ndi kuti zinkhanza mpingo ukuyendanso bwino. Taona ndithu ngati feyo mpingo wathu wa CCP pambenjere tili kuti tili ndi programu imeneyi imene azibambo amakambirana makamaka timakumana Sunday lililonse tiyamuka chipembedzo china chonse timakhala pansi kumana kwa 30 minutes ndipo kuti timakambirana zina ndi zina zokhuzana nkhanza. Imeneyi anthu ila ndi kwambiri ngakhalenso azimayiso mmakomo kuyamikira chifukwa cha programu imeneyi.
Thank you so much, colleagues. And this shows the role of male champions in ending violence against women. It's a very good practice that has been showcased there. I'm happy to inform you, colleagues, that we have been joined by our Deputy Regional Director, Madam Zabib Kavuma. She's with us and she will be offering her opening remarks shortly. Just before I invite her, I want to again remind you that we have translation services which is available. You just go down there where we have English and you can be able to get translation in French. We also have international sign in language interpretation, which is pinned on the screen to ensure that we are able to reach everyone. The study which has just been presented by Soneta, the executive summary is already available on our website, africa.unwomen.org. You can be able to access it. The full report will be available by end of next week. May I then take this opportunity to invite Madam Zabib to offer her opening remarks. And Zabib, just to let you know that we have had the presentation on the findings and recommendations of the study. And we now welcome you to give your opening remarks before we move to the panel discussion on this particular seminar. Welcome, Madam Zabib.
So good afternoon, colleagues, and of course to all the distinguished panelists and the partners as well. I'm very, very sorry that I was not able to join you on time. I was just caught up in another meeting and I couldn't leave it. So I'm really, really apologizing. And I know you've already started. I don't want to take up too much of the time. I think a presentation by Sunita has already been made in terms of the study. I think we've also been able to understand what are some of the issues and of course the data that is available that is showing us also in terms of status of gender-based violence, but also in terms of what women can access and cannot access and where some of the bottlenecks are. So I really didn't want to go too much into that. But maybe just to say that one of the things that we see in the study is, of course, that many countries do have the requisite laws in place, and these can serve as a foundation, right, for any form of gender equality. And that also in some cases or in some countries, we also have quite promising practices, that indicate ways to improve access to justice for women and girls. And some of these, as you may have already seen, in terms of ensuring a survivor-centered approach and how to access this justice and how it's being delivered. Of course, legislating also for the provision of funding for legal assistance, which a lot of times is also missing, strengthening the justice system in its and institutionalizing that, investing in interagency coordination, also initiatives focusing on needs of specific groups, and also monitoring and evaluating the implementation of legislation or practices. So we do see that there is also some positive outcomes in this. But of course, we also know that these practices are not seen at the scale, or they're not institutionalized in the way that we would like them to be. And often or not, that the laws are not harmonized also across the legal system. And more importantly, not even being enforced in practice. So there are still fundamental gaps that we need to address and we really need to look at. And I think as a situation, in a context where women are really seeking justice, where there's limited trust in formal justice providers, they often, of course, prefer to seek resolution through their social networks, right, and informal networks. So, but we also know that such informal networks cannot really replace the state obligation to provide adequate response and the action that needs to be taken for women and girls to really realize their rights. So, so really the idea is not to encourage and create parallel processes, but really making sure that the justice system is functional, so that really women can rightfully access what they need to access. And this takes me, I think, a bit also into the accountability framework. And this accountability gap, of course, means or remains a barrier to making progress on gender equality, because if you're not part of the formal system, then where is the justice that is being served? So we must collectively work to make access to justice a reality for all, and especially for women and girls. Now, this study also calls for more concrete, concentrated and collective action at all levels of society and across actors. So this includes government, it includes civil society, and also, of course, the development partners. And this is in line with the recent, also the Generation Equality Action Coalition. I'm sure a lot of you are familiar with when we launched the Generation Equality in Mexico and in Paris earlier this year. And of course, there is a separate action coalition on gender-based violence. And this is a multi-partner commitment with leadership, also from the government of Kenya, as we have seen, the Youth Trust in Zimbabwe, of course, UN Women, and also there are many other partners, civil society and government, who have also pledged to make sure that they really work towards the elimination of gender-based violence. So I really, in the end, I mean, honestly, I just want to reiterate our commitment as UN Women, but more importantly, as the regional office here in East and Southern Africa, to take forward, of course, all of these commitments that we have from the study, and really to have, dialogues and discussions and conversations that are very, honest and can really lead us to some of these solutions that we need. And we have to explore new ways of strengthening our collaboration, creating innovative approaches to be able to really address this multifaceted issue when we talk about access to justice. It's nothing new per se. I think a lot of it is reiterating and reconfirming and reaffirming what we already know. But now we really, really need to focus on what is the action that we want to take collectively and also, individually within our countries. And from a regional perspective, it is really important that we have some coherence in the way that we approach the issues, in the way that we share the knowledge, in the way that we produce the knowledge. And really, this is where we are at. And we want to be the contributor and walk the journey with all of you to really make sure that we get to the bottom of it, because this has been going on for too long. And we really, really need to now be creative and pull the forces together to make that change. And so that when women and girls are really violated in any one way, that they really don't have to fear to go and seek, the services that they need. So I want to leave it at that. And I'm sure there's going to be a lot of discussions. I know there's a panel coming up. So let's also learn and see, where this takes us. But I just want to thank you for being available and giving UN Women this opportunity to be able to do the study and share with you in this platform. So thank you so much. And once again, apologies for my delay. Over to you, Jack.
Okay, thank you so much, Zabib, and we appreciate the rallying call for making access to justice a reality for all women and girls. And we hope that the findings and recommendations of this study would add to that voice with the implementation of the findings and recommendations from various stakeholders participating in this particular seminar. So colleagues, we will then move to the panel discussion, and each panelist will be given between 5 and 7 minutes. I know we are running behind schedule, but I'm hoping that we will still be able to make it. So let's hear from Ms. Lensa Biena, who is the Executive Director of Ethiopian Women Lawyers Association, to give us perspectives, particularly from Ethiopia and also from the legal aid perspective on access to justice for women and girls. Ms. Lensa, please, you are welcomed, and you may proceed to speak. Lensa, you may need to unmute. Lensa, can you hear me? Okay, colleagues, as we wait for Lensa, we can move to the second speaker. We'll come back to Lensa. Ms. Adut Daniel Choi, who is the director for FIDA South Sudan. Please, you are welcome to make your presentation from a CSO perspective.
Hello.
Yes, we can hear you. Please
Good
proceed, we can hear
afternoon,
you.
ladies and gentlemen. Good afternoon from South Sudan.
Good afternoon, we can hear you.
Yeah, first of all, thank you very much for inviting me to this panel and this important seminar. I would like to express my apologies for joining in late due to technology challenges and poor connection. When I'll talk about the causes and opportunities and challenges in South Sudan context. In South Sudan, we do have negative and norms and traditions and negative cultural practices that contribute very much to sexual and gender-based violence. We do have also the conflicts, as you may know, the continuous conflict and the security tensions that studies throughout prove and confirm that women and children fall victims and survivors of rape and abduction during political violence or community conflicts. Also, the socio-economical situation in South Sudan. I mean, the socio-economical situation where people are facing a lot of economical crisis, and you find both parents going out for work, and then the children remain at home due to lack of maybe payment of school fees, and a lot of issues, including the conflict, the insecurity, the COVID-19 aspect of it has also contributed very much during the time when children are staying redundant at home. So many of them join gang groups. They also join drug addiction, and we had a lot of cases. We've been receiving a lot of cases, both at the Juba Teaching Hospital, which is the main hospital, where survivors of rape come to seek medical attention and psychosocial support. And even at the police stations, a lot of cases have been reported. The opportunities are, South Sudan has recently established a special court of sexual and gender-based violence with the funding from the Netherlands government through the UNDP. That court is specialized in addressing grievances of sexual gender-based violence and juvenile cases. Other opportunities, the continuous awareness and availability of legal providers, institutions, including the CSOs that offers free legal aid services, and women-led organizations like FIDA, who are continuing raising awareness through demonstrations, through radio talk shows. You know, lobby and advocacy continues for us to have the legislation in place. The challenges are many. First of all, lack of legal frameworks and policies in place in regards to sexual and gender-based violence. Also, not having the family law in place, not even having the Legal Aid Act in place. But then they always say the absence of law is not an excuse. So we do have the transitional constitution of South Sudan for the year 2011 that articulate and provides in the Bill of Rights articles that addresses women's rights and women's right to participate in public life. These are articles that combat sexual and gender-based violence. We have also articles that talk about the child rights and women's rights. I mean the women affirmative action to participate in the executive, legislative by at least 25% affirmative action, but that it's read together with the constitution. I mean, with the peace agreement in chapter 5 that talks about women's participation in public life and decision making by 35% as an affirmative action. That is minimum representation. Also, we have articles that talks about the right to find a family, and that and each shall have.
I think we are losing you, Mr. Dot. We have lost the panelist there. So I think, colleagues, we can move to the next panelist. And thanks for the emphasis around also the challenges and the interventions by. Mr. Dut, we can't hear you clearly. So, colleagues, we'll move to the next. Move to the next panelist. I know that there are colleagues who are raising their hands. We will have the quick presentations by the panelists. Then we come to question and answers from colleagues. So let's move to Ms. Lensa. Ms. Lensa, you have indicated that you are available. Please proceed, and you have 5 minutes to give us the perspective from a lawyers association, Ethiopian Women Lawyers Association. Welcome.
Thank you so much, Jack. And I'm sorry, I can't turn my video off because of the connection problem that I'm having. So it's better if I keep my video off and speak. I'd like to say thank you so much for UN Women for inviting me for this panel, and also for the studies conducted on the issue of access to justice. Let me introduce a little bit about my organization. Ethiopian Women Lawyers Association is one of the pioneer civil society organization in the country. It was established by a group of women advocates back in 1995. Almost now it's becoming 26 years since its establishment. Within this period, within this time, EWLA has been advocating for the rights of women and girls, especially, and also have been promoting the economic, political, social, and legal rights of women. And also we have been assisting them to secure their full protection. Aside from that, the organization has three major programs: the free legal aid, the provision of the free legal aid service to women and female children, and public education capacity building, research and law reform advocacy were the major programs that we had, that we have. Among our stay in the past 20, I could say more than 2 decades, most of the amendment of the laws and most changes come, especially in our country, regarding women rights issues, and most of the discrimination laws were by the efforts of EWLA. So almost it's been, as I said, it's been over 25 years now since EWLA started striving for the promotion and protection of women's rights issues. As I said, within the 3 programs, as it is, legal aid program is one of the core program from the establishment up to now. EWLA have been able to serve more than 2,100 needy women and victims of violence through the service of the free legal aid services. So our free legal aid service includes counseling, writing of court pleadings and court briefs and related assistances, and service to help them to access justice. Aside from that, we do also do mediation, court representation, and also sometimes we do survivors financial support and referral and temporary shelter referral linkage, psychosocial support, and following up of technical and also collaboration with the criminal justice organs regarding their criminal cases of clients are also service embraced by our legal aid program. Majorly, the association, I mean, it's as a trend, most of the cases that comes to our organization are civil nature, which most includes, you know, the GBV cases, marital issues, child maintenance, child custody, and all likely cases. And also we do we also see criminal cases, and also we refer them to the mandated law enforcement organs like the public prosecutors and policies. Aside from giving the shelters, as I said, we also do the referral linkage to shelters and various organizations. majorly as an organization which established to do access to justice more accessible to women and girls in our country. Our presence is in almost all the regions. We have offices in 8 branch offices aside from our head office located in Addis Ababa. So the service is accessible to, I can say, to most Ethiopian women in our country. And aside from that, we do also have a committee members who are trained paralegals to do to protect GBV and also to do this service, paralegal services to women who are in the grassroots levels. That is also one of the good structures that EULA had to, expand the access to justice issue to almost women and girls located in our country. The major challenges that the organization have faced was due to the last 10 years repressive law that we know, charities and civil society organizations law. It was a bit challenging time for EULA to render most of our services. But the good thing is the legal aid service succeeded this time, and we have been using our volunteers, and by mobilizing our volunteers who have been rendering the legal aid service all over the country. This is also one of the good success that the organization had. Aside from that, the challenge, most women representatives or handle their cases by themselves because of and they can't afford to hire lawyers, and representation is also one of the major challenges that we had. But this is also have been covered by EULA in the past times. Even though there are challenges, we've been using our volunteers, by mobilizing our volunteers. Such representations were being rendered to our clients. But aside from that, we come up with different strategies to, in the past 10 years, due to the challenge, we come up with different strategies to have such problems. And one is we have been training self-representation and assertiveness trainings to our clients so that they could be able to represent themselves even when we are not able to do that. And also we've been giving various trainings to the justice sector personnel, including the judges, police officers, and public prosecutors, which makes them to be aware on GBV cases, and also which was a good intervention for EULA to, to bring the justice sectors on board in the access to justice concept that we advocate for. During COVID, as it is mentioned in the previous, obviously, as it is mentioned in the study, DVK, the domestic violence cases was prominent, and within that period, we've been in discussion with the Supreme Court, and as it is mentioned, the court was open during that time. But aside from that, EULA also come up with a hotline service. Actually, this service have been there before 10 years. I mean, before like 10 years, EULA used to have this service. And unfortunately, due to the past 10 years, it was not able to provide that service. But during COVID, we come up, the hotline was open, and we have been rendering the service to 3 different languages where most women can access our legal aid services from wherever they are. That is also some of the good thing COVID brought to our organization. And aside from that, the opportunities, I could say, of course, there are many challenges that have been mentioned in the study, and also by the speaker who speak previously. But as a challenge, one thing that I want to mention in this stage is basically the support that we are rendering depends on project workers, which makes it very challenging for us, to upgrade it and to strengthen the system and the functions that we are providing. But we are still looking for a program kinds of support from our partners, and we are in discussion with that. One of our major partner on this is UNFPA, so we are discussing, getting a program kinds of support so that we include the psychosocial support. There are children who come to our office with their mothers, and so we want to also help by creating a child-friendly, conducive environment in our legal aid system, so that they also benefited from that. The opportunities that I can mention now is for our country is the amendment of the Civil Society Organization Proclamation, which is, bringing our services back to expand it more. So now we are, with the help of or with the assistance of UN Women, we started an office in areas that we were not able to reach previously. So it was also a good opportunities amendment of the law, and the attention given to GBV issues in our country is also a good opportunity that we can use, and we can grab the opportunity to work on accessing justice to women and girls. Last, maybe what I can say is we have to keep our efforts to make access to justice a reality to women and girls in our country and also all over the world. Thank you so much.
Yes, thank you so much. Sunita, if you can come in as my co-moderator to proceed with the other three moderators. Sunita?
Hi, okay, thank you so much, Jack. And thank you also to Lensa and to Adut from FIDA to giving your reflections. We're now going to move to our third panelist, Ms. Lizzie Kiama, who's a managing trustee from Disability in Kenya, to share with us her reflections and observations around some challenges of women and girls with disabilities in accessing justice and navigating the justice continuum, and also some good practices and recommendations. Lizzie, the floor is yours. You have 5 minutes. Thank you.
Thank you. Thank you very much. Good afternoon, everybody. My name has been said, Lizzie Kiama. We work primarily on advancing the rights and inclusion for women and girls with disabilities in Kenya. So our work has focused on the apparent stigma and discrimination in the portrayal of the role of women with disabilities in our society. The negative narrative perpetuating the charity and medical models of disability is the most dominant, and this leads to the discrimination of women and girls with disabilities, starting from the home front. There's also a laxity and a lack of prioritization, which is reflected in a lack of accessibility and stereotyping. And women and girls with disabilities are persistently confronted with barriers to social amenities such as healthcare, education, employment, transport, justice, among others. There's also an invisibility of language and references on disability rights within existing policy frameworks, which address the needs of persons with disabilities, and therefore a gap in meeting these needs. And practically, this translates to an absence of responsive programming and policy. Now, studies have shown that women with disabilities face barriers when accessing the justice system. There are communication barriers, for example, in accessing justice for women and girls with disabilities who want to report cases or even record a statement and testify in court, because they are not provided with the required accommodations like Braille, sign language interpreters, and other communication formats to ensure that they are able to communicate effectively. Women and girls with intellectual disabilities, for example, also face numerous challenges in accessing justice, where police and healthcare service providers do not take such cases seriously and often do not know how to handle them to ensure they are communicating effectively and that they are able to offer required services and support. They also, unfortunately, because of cultural biases, do not see them as competent witnesses. In Kenya, for example, women and girls with disabilities experience increased rates of sexual violence. This happens both in rural and urban settings, with a culture of silence. And unfortunately, most of the victims not accessing justice, because majority of the perpetrators are well known to the victim, including to family members. There is fear and a lack of faith in police officers. There is also a lack of training on disability rights among the police and the justice system, a lack of reasonable accommodation for the victims, a lack of safe shelters, and long processes within the court system, and lenient sentences when there is when the court processes do take effect. There are many cases of sexual violence where the accused has been set free despite overwhelming evidence. Many are ordered for retrial due to shoddy prosecution, resulting in extremely lengthy and tiring trials. Long delays in prosecuting cases have especially negative impact on witnesses with intellectual disabilities, who may have difficulties recalling details over long periods of time, and difficulties also in long-term memory and sequencing events. The Mental Health Act, for example, has also permitted forced treatment of persons with psychosocial disabilities. The Act mandates a loss of liberty on account of disability, where women with psychosocial disabilities are placed in institutional settings without their consent. Also, women with psychosocial disabilities in conflict with the law are constantly institutionalized in maximum security, and cases in court take so long awaiting mental assessments to be done and taken back to court, sometimes taking years. Whereas our Kenyan Constitution, for example, in Article 48, provides for the right to access to justice for all people. Girls with disabilities, on the other hand, who are in need of care and protection, are also placed in orphanages and institutions by the state with weak monitoring and inspection. Families place them in these institutions because they feel it is a burden to take care of their children. This is also exacerbated by extremely high poverty levels, resulting in many girls with disabilities being institutionalized all their lives, denying them the right of parental care, family, education, and the right to live in society. In these institutions also, there are extremely high cases of sexual and physical violence. And unfortunately, a large number of these children remain in orphanages that are unregistered, as noted by the Committee on the Rights of the Child in its last evaluation in Kenya. Some recommendations, a majority of the recommendations have been reported by the previous speaker and in Sunita's presentation, so I will not repeat those. But some opportunities that we have seen are that it is important that we prioritize the rights of women and girls with disabilities within our programming and our policies in our institutions. It's important that we also invest in strengthening and building the skills and capacities of communities of women and girls with disabilities to ensure that they can meaningfully be represented, or they can meaningfully represent themselves, and that they are participating in all spaces. Additionally, and as a result of the COVID-19 pandemic, we are seeing increased opportunities in leveraging technology to ensure access to justice, both offline and online modes, such as mobile phones, for example, to collect and document the experiences of women with disabilities. Social media to increase visibility on the rights of women with disabilities, and also to shift public perceptions on disability. At Disability Trust, for example, we have been using technology to advance the rights of, and specifically around access to sexual and reproductive rights and gender-based violence. We introduced a toll-free service, which we call Mama Siri. Siri is Swahili for seek, and here we are trying to ensure that women and girls with disabilities can access information and can speak in conflict. This is managed by women with disabilities. We piloted it in 8 counties in Kenya, and it serves as a referral on information and networks, local networks around gender-based violence, sexual reproductive health, legal information, and mental health. The women are trained to support other women with disabilities on where to go for help, what to do, what legal action to take, to go for assistance, where the safe spaces are, and generally providing support for women with disabilities. As I said, it's a service that is spearheaded by women with disabilities who also understand and empathize with the experiences of other women with disabilities. And we are running it in the 8 counties where we have presence, where disability has presence. and we have bi-weekly training. There's a lot of lessons that we have learned around using technology. Of course, there are challenges. We believe technology also provides an opportunity for reaching more women with disabilities, and particularly when the initiative is owned at community level, there's a lot more impact that we have reached that we have been running for this time. And thank you.
Thank you so much, Lizzie, for those reflections and the recommendations. I will now move to our fourth panelist and have the pleasure to introduce Justice Zione Ntaba, who's the National Project Coordinator of Women Judges Association of Malawi. And I'll jump right to you, Justice Ntaba. You have the floor for 5 minutes to share your experiences as a judge in supporting women and girls in Malawi. The floor is yours.
Thank you so much. I think let me start from the point of view that access to justice is a fundamental right enshrined in the Constitution in Malawi. And this allows us at least to ensure that there's provision of legal remedies by the courts, especially, which is integral to the use of the courts itself. But also that one of the things that we have also had to understand as women judges is that access to justice meaningfully contributes to a lot of rights in the Constitution as such. So when we're doing the work that we're doing, we enshrine, or we, should I say, calcate all our programming in the concept of access to justice. But I do realize that when we talk about access to justice, especially for women and girls, and especially in terms of the space that we operate in, there's a lot of challenges with the cases itself, whether it's the hearings or the sentencing. But in terms of let me just start with the major challenges in terms of the infrastructure itself. One of the biggest things we have is we do not have a lot of infrastructure, especially in the rural areas or the remote areas. And our structures also are not gender friendly, neither are they disability friendly, and to some degree, age appropriate. We also have a lot of spaces in terms of there's a lot of travel that people have to do to get to courts, to reach courts. From the village to the courts, they would maybe walk about over 20 kilometers, 30 kilometers. And the cost of that is also very much something that frustrates access to justice, because people cannot afford the transport itself. They cannot afford to stay overnight for cases that are going to go on. Like when you look at sexual violence cases, they don't finish in the same day. People have to travel back or come back on a different day. The language itself, our language is still English. We interpret into the local languages, but that also in itself means there's a lot of translation that is lost. We also do realize that there's also a lot of lack of user-friendly services by us as service providers because of the language that we use, the fact that we still legalistic in the words that we use. So that is something that we've seen as a major challenge in terms of cases that we've been handling for women and girls. And in terms of hearing, one of the things that we just finished a project under Spotlight, and we've been calculating our data. Cases start fine, but you find that because a person is on bail, once they've reached the case to answer stage, they disappear. A warrant of arrest can be issued, but they are unable to go and find the person because Malawi is vast and there's no postal system and there's nothing attached to them as a person, especially people from the rural areas. So that's something we're realizing, that cases start, but they don't finish because of a lack of people absconding from bail. But we also have a lot of attrition in terms of from the cases itself. Once the process is going through, you start hearing that they want to withdraw the cases. And this is because they would have gone into the village and they've started discussing with the perpetrator on withdrawing because they will help them, or you hear that they will marry them, or such issues that are coming into play. And I believe those are things that we are struggling with in terms of access to justice. But we also realize that sexual offenses themselves have peculiarities that are not programmed as they should. For instance, a lot of women, we don't program into cases the need for intensive social support.
I think we are losing you.
And that is something that we are realizing and seeing. And that's been one of the areas we've. Am I back? Let me go
You're
back.
back.
Yeah. Yes.
I'm getting feedback. Okay, no feedback. Huh? Can everybody hear me?
Yes, now it's better.
So one of the things that I wanted us to highlight, one of the things I wanted to highlight in terms of the issues that we've seen in terms of the cases itself, is that we've moved in terms of sentencing. It's not a challenge, but it's an opportunity. Most of our sexual offenses cases, as we've been going along the process, we've seen that judges, and especially judges of the High Court, they've been giving very stiff sentences in terms of the defilement cases and rape cases. You've gotten, like, for the last 7 years or so, we've seen our sentences rise from around 9 to 10 years to about 40 years coming through. And that in itself has actually sent a wave across the country where people are saying, if you defile a child or you rape a woman, this is the kind of sentencing you're going to get. And that you've seen our newspapers, our media, and we've even heard it from the people in the ground, especially we do this through mobile courts. So the judges will do this in the rural areas. And that in itself has acted as a major advocacy tool for us and an opportunity that we want to continue using. I wanted to highlight that.
Apologies, Justice. I think the sound has cut off quite badly. Apologies, Justice Ntaba. The sound has cut off quite badly. But we were able to hear that the change in sentencing. So I think that point did come out in that shift that has been seen. But I'm sorry that the connection wasn't very strong for the full points.
Okay, are you able to hear it now?
Yes, so maybe I could ask you to summarize or give your final message on this point.
Yeah, my final message is that, well, especially during COVID, one of the things that we realized as the role of the court is that we need to be present, we need to be accessible, we need to be inclusive. And I say this because we moved to what we call remote courts or online courts. But that is very difficult for people in the remote areas. As such, the way we thought about it as WAWG and as the judiciary of this country was to actually do more mobile courts. So seek resources through Spotlight itself. But we're also getting resources through Chidongamo project, which is an EU project, to actually get more mobile courts so that we don't leave out the people who actually need it. So I would say that would be the last message on this. Apologies about the voice and the cutting out. Thank you.
Thank you so much, Justice Ntaba. And I think that last point around the importance of the judiciary being present, accessible, and inclusive comes out loud and clear. Now I'd like to pass to our final panelist for this piece of the agenda. And I have the pleasure to introduce Dr. Beatrice Akua-Duncan, who is UN Women's Policy Advisor on Rule of Law, Access to Justice, and Constitutions. Beatrice, you have the floor for 5 minutes to share your reflections and observations. Thank you.
Thank you, Sonata. I cannot even begin without saluting Justice Ntaba, as well as my predecessor speakers from the Women Lawyers Association, because I personally respect the tremendous roles that they are playing in enabling women to access justice. So my greetings to them, and I salute them this morning. I wish to commend the Regional Office for Eastern and Southern Africa of UN Women for this study. I have read the executive summary, and I see that the report is of very sound quality. One thing that strikes me is the fact that the report speaks to the issue of gender-based violence, but does not focus on that alone. It does focus on the multi-sectorial nature of the issue and the intersecting issues that need to be addressed if we are to address the ability of women to access justice. So that was a very good move on your part, Jack, and I wish to commend you for that. One of the critical issues that I wish to bring to the fore this morning is the role of the family and the unequal power relationships within the family, where we still continue to experience the notions of male guardianship and male dominance within the family. This is definitely an issue which continues to escalate violence, particularly at the domestic level. And again, within this same framework, we see a specific gender division of labor at play, where women's roles continue to be limited to the reproduction as opposed to the production, which would enable women to be more economically independent. And again, within this COVID crisis, we saw an escalation, or we have seen an escalation of unpaid care work and the involvement of women in unpaid family enterprise. So for sure, if women are not supported to be productive, as opposed to engaging in more reproductive and unpaid care work, then we would definitely see an escalation of violence. Within this same discussion, we have to understand the different types of marriages that exist across the continent. And we see that statutory and civil marriages are less common in comparison to religious and customary marriages. In recent times, we have also seen the rise of informal relationships. These are relationships in which men and women live together without actually formalizing their relationships. Again, this could be a risk factor for violence for many women, because there is really no kind of support system unless the laws of the country acknowledge the existence of such relationships and actually treat them at the same level as marriages. Not to forget the fact that early and child marriage is also on the ascendancy, because in some countries, the laws actually permit girls to marry at an age below 18 years, and particularly with parental consent or with the consent of a judge. And I think that where the consent of a judge comes in, this really leads to a betrayal of the role of the justice system. How can a justice system really give consent, or allow child marriage? This has to be abolished completely, not only in Africa, but all over the world. We cannot see our judges being involved in the commission of a crime against a child. So the involvement of the judiciary in endorsing child marriage needs to come to an end. I wish to come back to the role of the Women Lawyers Association and to encourage all of you to continue with the good work that you are doing, because you are the ones who are creating awareness among women and lifting the scales off their eyes to be able to access justice by increasing demand for justice among women. So please, for all of you, in case there are donors who are participating in this event, I would encourage all of you to render continued support to all our women's associations. To be honest with you, without them, a lot of women will have no legal standing, and we need to support them. We also need to look at the demand side of justice, the kind of jurisprudence that is coming from the bench. Some of the jurisprudence is progressive, but other types of jurisprudence also tends to be retrogressive. We like to see the kind of jurisprudence where the judges are telling us that if a woman is not able to prove that she has contributed financially to marital property, that she can still be a joint owner of that property because she has contributed in other ways, such as through unpaid care work. We like to see that kind of progressive jurisprudence, but the kind of retrogressive jurisprudence which states that you know, a woman can do otherwise in this day and age cannot be entertained anymore. I know that my colleague Hodan is also going to give closing remarks, but what we have seen from places that she has worked in Uganda and Tanzania is that when you focus and you laser focus more on male judges, you tend to reap a lot of dividends by way of their sensitization, by way of equipping them with the knowledge to be able to deliver progressive judgments. So in as much as the report is saying that we need to focus on establishing women-only courts, I just want to caution that that could actually backfire, because when you have women-only institutions, those institutions can sometimes be relegated to the background. But when you mainstream gender into the justice sector and ensure that both male judges and female judges are well equipped to be able to deliver effective decisions that would impact positively on women and girls, you tend to reap more dividends. And as Hodan would tell you, this can be done through the creation of bench books that would enable them to understand the gender dimensions of being a judge. In the long term, I wish to say that it will be very critical for us to invest in continuous legal education, not only for judges, but also for lawyers, for prosecutors, for the police, and all other personnel who are part of the justice chain. By and large, this initiative that the Isaro region has undertaken is a good one, coupled with the engagement that you have with traditional leaders. If you could connect the dots and add it all up and make sure that it becomes a comprehensive program, I truly believe that you'll be making a huge difference in the lives of women and girls. So thank you so much and congratulations.
Thank you so much, Beatrice, for those reflections, remarks, and the recommendations for how we take this work forward. So we've come to the end of this session. I do note that we are still behind on the time, so I'll pass the floor to Jack and we can look at how we can continue for the final 3 parts of the session. Thank you,
so
Jack,
much.
over to you.
Thank you so much, Soneta, and thank you to all the panelists for very useful inputs that we will also take forward in terms of operationalizing the findings and recommendations of this study. We appreciate your time. So we move now to questions and answers, and I have seen quite a number of hands. Dear colleagues, you have the opportunity to write your questions and answers in the chat or to raise your hand. And my colleagues, Evelyn and Joshua, will admit you to speak. So if you have any questions, please raise your hands and we can admit you to speak. If you could just use the raise your hand button, the icon is up there. If you go to more than, okay, I can see already we have colleagues who have raised their hands. So can we start with Stephen and then we come to Saba? So Stephen, if you can unmute yourself, we have enabled you to speak. Please go ahead and ask the question. Stephen? Just should you help us to admit Stephen to be able to speak?
Jack, he is
Yes.
able to speak, but he is not. So maybe you could move to the next person, who is Saba. So I'm
Okay,
going to mute Steve. Yes, thank you.
Okay, Saba, please proceed.
Thank you. This is Saba from the Network of Ethiopian Women Associations, and I'd like to extend my congratulatory remark for the organizers as well as the presenters. It was a very informative and provided a reflection space for all of us on access to justice for women. My question is also a kind of thing that we all need to think about in terms of when we always talk about justice, because we are talking about in a context of the courts and justice being neutral, courts, judges being neutral. We have this challenge as we campaign for gender-based violence cases. We try to influence judges, but where do we draw? Maybe this question may go to Beatrice, the final speaker from the UN Women, because you were talking about the jurisprudence and how courts shouldn't be like women only. I also don't agree with that. I also agree with what you said in terms of not having women only courts, but to have a court that is sensitive to those issues that women find it difficult in accessing justice. But where do we draw that? Because when we campaign on courts, we campaign on prosecutors, we campaign on the police and the prosecutors as well as the enforcement bodies in general. And that's where the question always comes. You cannot bias justice because the courts, the judges have to give their decision in a neutral manner. But we know that if we keep a blind eye to those aspects of women that are suffering, that are being violated, then we will not have a real justice. Justice will not be served. So how do we balance these two arguments is my question, because we always come with this question as we advocate for access as well as for justice, for gender-based violence, as well as to other women rights issues. Thank you very much.
Okay. Thank you for that question. Maybe we get one more question and then we can proceed. We can get the responses. We also take note of the comments around trainings and also working with the police and law enforcement agencies in terms of ensuring that they are gender responsive in their approach to law enforcement as well. Winnet Band has given that particular comment. So maybe as we wait for other comments, Beatrice, if you could respond to that input by Saba.
Yeah, thank you so much, Saba. That's a very good point. So the point that I was making was that we definitely need more women judges. We definitely need more specialized courts because it is these specialized courts that help us to accelerate the pace of court hearings. What I am saying is that we should not be dependent on only that approach, but we should also adopt a gender mainstreaming approach in the other courts so that other male judges will be sensitized enough to contribute to this effort. So I believe what we need to adopt is a two-pronged approach, where we have the specialized courts. And in these specialized courts, we should encourage women to be on the bench in these courts. But at the same time, we need to ensure that other judges in the mainstream courts are equally capable of delivering gender-sensitive judgments. So if we adopt this approach, we will have a win all round. I was also cautioning that an over-concentration on specialized courts could also lead to a situation that we are seeing all over the world, where these specialized courts are really not being given enough budgets to function properly because they are siloed. They are seen as separate institutions in the minds of some technocrats. So if we want to overcome that challenge, then it is not going to be enough for us to just advocate for the establishment of specialized courts. We also need to undertake an effective analysis of the national budgets to ensure that these specialized courts are given sufficient resources to be able to undertake their mandates. So I'm advocating for a multi-pronged approach rather than a one approach, because a one approach is definitely not going to work. Thank you very much.
No, thank you so much, Beatrice. And I think a multi-pronged approach has proven much more feasible than you would say a specific one-size-fits-all kind of approach. Sunita, you have some questions in the chat by Kagoya. If you could please respond to her.
Sure,
I mean, to the question.
You.
Yes.
Thank you, Jack. I've actually been typing them in the response, so I hope that is sufficient, recognizing the time and wanting to respect our approach to kind of keeping the time. If that's okay, I'll keep them in the chat, and I hope everyone will be able to see those. Thank you.
Jack, you are muted.
Sorry, colleagues. Jacqueline has raised her hand. Evelyn, if you can allow her to speak.
Thank you, Jack. The reason I had raised my hand is because of the previous comments that I had made concerning compensation. And I think Sunita has already made a response in the chat. Thank you.
Jack, please unmute Jack, please.
Yeah, my apologies, colleagues. So I'm saying that thank you so much. The report has an email address. We will continue to engage on this subject matter. If you have any further questions, please feel free to write to us, and we will be able to respond accordingly as we move forward. But we appreciate the engagement that we have had today. I think we'll move to the next session, which is going to give us a synopsis, or rather summary of the key issues that we have discussed in this particular seminar. And I welcome back Sunita to give us those key points that are coming from the discussions of this seminar. Sunita, please.
Thank you so much, Jack, for the time, and I will try to be brief in terms of some of the key points. And we also appreciate and take note again of all the very valuable contributions that have come from the panelists today, as well as in the chat from all of the participants. I think, as we start out and as we, began the session, the emphasis that access to justice is a fundamental right. And as we work to improve and strengthen women and girls' access to this, that connectivity of it with other rights is really essential for us to remember. We also know that women's participation and representation, not only in the justice sector, but beyond, is again essential to really transforming how women and girls can enjoy their right to access justice, as well as access it in the process. We know that we've heard the different challenges that are in place, whether it's from the legal frameworks themselves or the infrastructure that exists and the attitudinal barriers and social norms that challenge women and girls in accessing these rights. But we also know that over and again, we've heard the need for long-term investments using various approaches, recognizing that not one size fits all, but all actors need to be, and all stakeholders within communities, from the individual women and girls seeking services to their family members, to their peers, to the community leaders and the justice service providers, as well as other sectors. All actors need to be really involved. And I think we heard through the different conversations today, the need to recognize that the response to each individual will be as distinct as each individual, because no one person is coming to the experience with the same background, with the same decisions or desires. And I think keeping decisions in the individual's control, as we heard from our panelists, is also really critical, so that when we're thinking about improving services and institutions, recognizing that diversity of women and girls themselves as a starting point will help us make sure that the range of services, the range of options reflect that diversity in practice. Alongside the investment over time into these diverse approaches, the education, again, of different actors, from community members and family members, justice providers, not only around gender-based violence, but also gender issues more broadly around power, control, disability inclusion and rights, and really moving towards enabling providers to see that self-representation, decisions by women and girls in the process, and having adequate peer support will be really essential in the process. There's a lot of great opportunities of networks and coordination between institutions that we need to recognize and build on. This is not about one institution acting alone, but connecting the dots, I think, is one of our speakers have said, and really tackling in a very explicit way some of those stereotypes that we see, starting from within our homes and within ourselves as individuals, recognizing that we carry those biases and norms in how we operate as individuals and in our institutions. So finally, some different opportunities that we heard that we need to build on. There are opportunities in amending legislation. There are opportunities in how jurisprudence is carried out that we need to really monitor and elevate visibility on. We need to really ensure that we look at power structures within families and patriarchy, and how other entry points for women, whether that's economic empowerment, political participation, are equally linked to issues of violence and access to justice. And prioritizing the rights of women and girls with disabilities, women and girls who face multiple forms of marginalizations, and addressing impunity and attrition in the actual justice process. So I think I really liked the points of Justice Ntaba last message around making sure justice is present, accessible, and inclusive to all women and girls is a really nice way to end the summary of the conversation. And we look forward to sharing with everyone and consolidating some of the messages shared today. So I'll end on that and pass back to you, Jack. Thank you.
Thank you so much, Soneta, for that insightful summary of the discussions of this seminar. And we really appreciate all the inputs. I think we are coming to the end, and my apologies again, colleagues, for going slightly beyond the time. We are now coming to the closing remarks, and I welcome our country representative for Tanzania Country Office, Ms. Hodan Adu, to offer the closing remarks.
Thank you so much, Jack. Really pleasure to be here with you all and listening to these excellent deliberations and sharing of experiences across this wonderful region that we as UN Women colleagues are very fortunate to serve in protecting and supporting women's rights in this region. So thank you so much for that. It's been really very rich experience sharing. And want to, of course, thank our the regional office for giving me this opportunity to give you some closing remarks, but also to thank and congratulate Zabib Kabuma, who is the Deputy Regional Director of UN Women, and under her leadership led this important work for the region, for UN Women, for its partners, both in government and civil society, and really a rich source of information that we could all use in our own country settings. But of course, you had to have the foot soldiers, as they say, and that's Dr. Jack Bebe, who has been in this process for many, for a couple of years. I know that with my team, he's been very much engaged and providing much leadership in terms of the support that we could provide in the direction and the analysis. And of course, my dear sister, Sunita Kamina, excellent technical expertise. It really shows the strength and the growth of our regional office. And thank you for that. And of course, thanking the authors of this study, the research team that put together this very important piece of work. And I cannot not recognize and say thank you to my sister Beatrice Duncan from our headquarters for her excellent insights, her advice, which is really, we cherish it very much. It has influenced, at least during the period of my work from Southern Africa to East Africa and even to the Horn. So really want to, thank her for many years of support to our programming. But I think what's important also is the other colleagues on the background as well, UN Women and the partners, our translators, everyone who had made this meeting possible. Want to, on behalf of my regional office and my deputy regional director, to thank you all for participating, all the speakers, all of our partners from the different countries that shared those very rich experiences and the challenges that you're facing. We are with you all the way, and we'll work definitely with you to support the women and the girls in the countries that you are in. And want to thank you for taking time from your very busy schedules to share your country experiences. And of course, to our participants for your excellent and thought-provoking contributions this afternoon. I can't leave without saying something about Tanzania, of course. So, how does this relate to our work here in Tanzania? And I just wanted to say that for this study, it comes really, not only for Tanzania, but I think for all of our region, it's an opportune time when we are reaffirming commitments to at many levels to fast track the implementation of the 2030 agenda. It's only 9 years away, so we need to really get our act going. And of course, not to forget our Bible, our Quran, our Torah for women's rights, the CEDAW, and particularly for this particular meeting, the CEDAW recommendations number 33 on women's access to justice, that we need to really push forward, look at these challenges that have been persisting for many years, but we need to move forward, look at new ways and identify perhaps maybe new partnerships and reinforce our efforts. Tanzania, like many of the countries that have shared their experiences today, and of course in the research that we are looking at, shows multiple, forms of gender-based violence, from intimate partner violence to sexual violence by non-partners, and for us, the main thing that we're at the country office working closely with our partners is the issues around changing legislations, addressing the child marriage bill, but also looking at issues such as FGM, which is a persistent problem for many of our countries in the region, especially in the Horn and East Africa. Women in Tanzania still face, as I said, several forms of violence, but also several forms of discrimination, with some of the key challenges to access to justice, including the existence of gender discriminatory laws, lack of effective and accessible legal aid system at the grassroots level, lack of trained personnel to handle access to on cases of violence against women and girls, and of course the use of informal and traditional systems which perpetrate discrimination and violence for women and girls. Our triple systems of justice, particularly the customary justice system in Tanzania, often leads to the perpetration and reinforcement of discriminatory social norms and blocks access to justice for many women and girls and children, I should say, as well as vulnerable groups, as was mentioned earlier, people living with disabilities, women living with HIV/AIDS, and countless other marginalized groups. There is a need to work across the board to reform customary justice systems, I think, in our region. And in Tanzania, we're working closely and trying to analyze that to ensure that we are helping the country to be in line with the international principles and standards. The findings of the study reemphasizes our Tanzania context, which we are working to address through a multi-pronged approach and a number of interrelated and interconnected initiatives. For instance, our support to the provision of legal aid services for women in rural areas is very much connected to our support to local government authorities, our support for women's economic security and rights, and on, of course, the protection of women from violence. We found the important contributions of women human rights defenders and women associations, such as our partnership with the Tanzania Judiciary Women Judges Association. Those have helped us to mobilize at the highest levels of the judiciary to adopt the gender bench book that Beatrice was referring to. And it's something that we're very proud of. The gender bench book for women's rights seeks to provide a user-friendly reference guide for judicial officers to strengthen the gender responsiveness of judicial cases. And we're really pleased that it's going to be officially launched by the president of Tanzania next week. It shows the commitment at the highest level of government to ensure that women's rights are protected. And we hope to roll it out with funding, of course, to various training workshops for the judiciary across the country. Another thing I think it's important that the research had found, and we are adapting it and building on this work, is on investing in data, evidence, and knowledge generation to ensure effective interventions that are most essential and most relevant in the context that women's lives are that women must see as a priorities as well, and of the realities that they're living in. I think, the study did mention the lack of baseline data and reliable and consistent measurement systems have limited responsiveness and impact on GBV interventions. To address this, UN Women in Tanzania is supporting the national statistical institutions in both mainland and in Zanzibar, as well as the ministries responsible for gender issues to conduct population-based surveys on violence against women. And we would love to share that experience with you all. Through another survey in partnership with OECD, we are supporting a Tanzania-specific social institutions and gender issues survey that examines the perceptions and attitudes on gender-related issues and social norms and practices that are driving discrimination against women and girls and contributing to the high prevalence that we have on gender-based violence. So it's looking at qualitative and quantitative data to then unpack and see what are the best responses and how do we then make strategic interventions with the key institutions, whether they're formal or informal, and using that analysis to move forward on evidence-based programming. The lessons from the gendered impact of COVID pandemic has been, of course, been stated throughout today's discussions, and it's been reported in so many cases. And we know then that the justice system is no exception. I think what the COVID has taught us is that our systems in place are already ineffective, and that the COVID has even further exposed those inequalities across the board, whether they're on gender, but on also issues related to geographic distribution, ethnic, racial, and so many other characteristics that we need to take into account. So if we want the justice delivery system to be effective, it needs to be responsive to all people, especially those that have been disenfranchised over the years for so many different reasons and so forth. So we need to look at those categories or groups of individuals who have been left behind, and how do we make sure that the justice systems that we are rebuilding, it is inclusive and it is not leaving anyone behind. We must also ensure, of course, as was said earlier, the multi-sectoral approach to addressing the needs of survivors of violence, looking beyond the justice system and putting in place those strategies and interventions that women can best succeed in and advance socially and economically and politically, and are able to strengthen their decision-making power. As I come to an end with my closing remarks, I would like to share a quote from the United Nations Special Representative on Sexual Violence. It's in conflict, but I think it's relevant what she's saying. So this is the Special Rapporteur, the Honorable Pramila Patten, and I quote, she says, justice is essential to helping women survivors cope and transform their lives. Survivors also demand material assistance and other services to rebuild their lives and livelihoods. It is time to deliver on these demands and put survivors first. That for me was a key message that was coming out from this research and from the discussions. And I want to commend you all for this excellent deliberations, and thank you on behalf of our regional office. And with that, I would like to mark the end of the webinar, and thank you all for joining us. Asante sana.
Thank you, Hadan. Thank you, colleagues. And we'll keep engaging on email that is available on the back page of the publication. Thank you so much.
Bye-bye.
Bye.